Welcome to the HRnow 2014 Labor and Employment Law Update, brought to you by Judy Ballard. That's me. The minimum wage increase, effective July 1, 2014, minimum wage is going up to $9 an hour for non-exempt employees. The minimum wage will again increase January 1st, 2016, up to $10 an hour. Keep in mind that this not only affects your non-exempt employees, but will also impact exempt employees. Number one, from the standpoint that you need to make sure that your workers are being properly classified. That is a very hot area of litigation now from our government, is just going door to door and determining who is not classified correctly between exempt, non-exempt, and also between a worker and independent contractor. But how this affects your exempt employees is because one of the main ingredients and parameters for exemption is that they have a monthly salary equivalent to no less than 2 times the state minimum wage. So keep that in mind. And so you should not wait to take a look at all of those things, but also your exempt employees and your non-exempt employees. So review everybody that is anywhere near the minimum wage. Review all exempt level employees that may be possibly affected. Take a look at all of your salary grades and update those where necessary. And then also strategize your review for the 2016 change as well. So whatever you go through now, that you're not waiting until the last minute to go through that as well for 2016, because that'll be January 1, and things get busy at the end of the year, so you want to make sure that you have a plan. Any domestic workers, and this involves childcare providers, caregivers of people with disabilities, elderly caregivers, housekeepers, maids, not workers that work in accredited facilities, like a convalescent hospital or so forth. Those will not be affected. This requires that overtime be paid to all domestic workers when they work over 9 hours in one workday or 45 hours in one work week. So it's important to, even for domestic workers, to have a clearly defined work week and work day, and when those begin and end. And then babysitters, casual babysitters, that are typically, teenagers that are just casual babysitters, watching the kids for a few hours. Typically, they are exempted from this. And typically, parents will just pay whatever the rate is, $10 an hour, whatever it is that they end up paying, as long as they are not performing a significant amount of work like a caregiver would. And that involves anything other than basic supervision, feeding and dressing the children. So some of the things to be aware of is just confirm that your covered workers in this category are actually completing a time card so that you can determine when they're going over 9 or over 45 in 1 week, and then pay over. There is an addition to protected classes. AB, Assembly Bill 556, amends the FEHA, the Fair Employment and Housing Act, adding military or veteran status to the classes protected from employment discrimination. And it also allows employers to still identify members of the military or veteran for purposes of awarding a veteran's preference as permitted by law. So keep that in mind. If you're held to certain guidelines on what you need to hire in which particular category, then just make sure that that actually does apply to you and that you're not getting into any conversations about somebody's veteran status, even as innocent as it may be, just applauding them for supporting our country and doing all of those things. But you want to make sure that you're not entering into those conversations and then eventually not hiring that person and then having to prove that you didn't use that information as a part of your hiring decision. So just make sure that you're reviewing all of your hiring practices and train your hiring managers. Anybody that will be the selection process, they may enter into these conversations very innocently, and you don't want to get yourself in trouble there. The heat illness recovery periods. This goes for Cal OSHA's heat illness prevention program. And right now, employees are allowed to ask for at least 5 minutes whenever the employee feels they need to do so. Now what's added here is that the failure to do so by an employer is going to go along the same lines as paying the premium wage of 1 hour pay, just like a so one of the things that you should really do there is train all of your supervisors on what those cool down periods are, and then take a look at your handbook policies. If you're one of the employers that has an outdoor work environment, you have to comply with this. So it's important that your supervisors know not to make it difficult for your employees. Changes to our sexual harassment laws. Senate Bill 292 revises the Fair Employment and Housing Act and says that employees who assert claims of sexual harassment do not need to show that harassment was motivated by sexual desire. And that sexually offensive conduct or statements that are unrelated to sexual desire can now form the basis for a sexual harassment. Criminal history inquiries. Right now, in California, we are prohibited from asking employees or applicants about any arrest that did not result in a conviction unless it's pending trial. And there's a variety of different things that we have to add if we're asking this on an application. There is very specific verbiage we must put on the application. We cannot just simply ask, have you ever been convicted of a felony? We need to ask very specifically, and then we need to rule out the older marijuana conviction. So if you need help with that or you're not doing it now, make sure that you know what you need to be putting on your applications. Senate Bill 530 now adds that to that list any information concerning a conviction that's been judicially dismissed or ordered sealed, unless the employer is required by law to obtain the information, unless the applicant would be required to possess a firearm or use the firearm in the course of their employment, whether the individual has been convicted of a crime, is prohibited by law from holding the position sought by the applicant, regardless of whether the conviction has been expunged, judicially ordered, sealed, statutorily eradicated, or judicially dismissed. Or the employer is prohibited by law from hiring an applicant who's been convicted of a crime. So you may be, you may have a situation where your employees need to go on site of a school involving children. And so you may have a situation where you're not able to hire that person because of that situation. So to those categories, you can't enter into that, gathering that information. So you need to review your hiring practices. You need to train your supervisors and hiring managers on all of the questions to ask and not to ask. And then review your background and reference checking practices as well. Leave for peace officers and rescue personnel. Currently, employers with 50 or more employees must permit an employee who's a volunteer firefighter to take temporary leaves of absence, not to exceed an aggregate of 14 days per calendar year, for the purposes of engaging in fire or law enforcement. Now, Assembly Bill 11 requires that these employers also permit employees who perform emergency duties, such as reserve peace officers or other emergency rescue personnel, to take that same leave. So you need to take a look at your leave policies and your handbook and make sure that it's complete. Victims' rights. Currently, there are victims' rights for those victims of domestic violence or sexual assault, and now adding to that stalking. Any victims of stalking, they will be able to have the same rights as those victims of domestic violence or sexual assault. Employers must engage in an interactive process with the employee to determine effective reasonable accommodations if required. And the employers can require a certification of victim status before granting the reasonable accommodations, but the most important piece of that is obviously granting them the appropriate leave where applicable, and also entering into that interactive process. That seems to be one that employers currently may not discharge or in any manner discriminate against an employee who's a victim of a crime, domestic violence, or sexual assault for taking time off to appear in court. And then now we're adding also stalking there. Train supervisors and managers on when they receive this kind of request on what to do, and then review all leave policies. Assembly Bill 442 authorizes the California Labor Commissioner to award liquidated damages equal to the amount of unpaid wages owed plus interest when an employer violates California's minimum wage law. So that's something to keep in mind now that minimum wage is going up, and again, in another year and a half, will be going up again. And then Assembly Bill 1386 makes it easier for employees to collect damages awarded by the Labor Commissioner. So once the final award, the decision or award becomes final, the Labor Commissioner can place a lien against the employer's real property for up to 10 years unless the order is satisfied or released. Senate Bill 462 limits the employer's ability to recover its attorney's fees and costs in a wage action. An employer who prevails on a wage claim can only recover its fees and costs if it can prove that the employee brought the court action in bad faith. So that would be usually very difficult to prove. This is for employers who happen to be car washes. Assembly Bill 1387 increases the employer's bond requirement from $15,000 to $150,000. So that is pretty significant increase, and this is for the benefit of the state to compensate employees damaged by the employer's non-payment of wages. There will be an exemption for employees who have a collective bargaining agreement in place and meets specific criteria. But if you're a car wash, you need to know that this is for you. Paid family leave currently offers up to 6 weeks of wage replacement. This does not offer job protection, in case you're ever confused about that, but it does offer wage replacement benefits to workers who take time off to care for a seriously ill child, spouse, parent, domestic partner, or to bond with a minor child within 1 year of birth or placement of the child in connection with foster care or adoption. Effective July 1, 2014, the law expands the scope of the family temporary disability to include time off for a seriously ill grandparent, grandchild, sibling, or parent-in-law. Immigration status. Assembly Bill 263 prohibits an employer from engaging in an unfair immigration-related practice when an employee exercises a right protected under the state labor and unemployment laws. Unfair immigration practice includes requesting additional information about their immigration documentation, using E-Verify when not authorized, threatening to file or filing a false police report, or threatening to contact or actually contacting immigration authorities. So be real careful with this. I've seen with the E-Verify situation, I've seen employers that have a suspicion that somebody is undocumented, and so they take it upon themselves to run that employee through E-Verify, and that's not really how it works. You can't really do that. Again, it's the same thing in most HR-related situations. If you do one, you must do all. So this is a situation like that. You cannot use E-Verify on a suspicion basis. There is a reputable presumption that adverse action taken within 90 days of the employee exercising a protected right is retaliatory. And employees can bring a civil action for violation of the statute and seek damages, equitable relief, penalties, costs, and attorney's fees. SB 666 will also subject the employer's business license to suspension or revocation if the employer's been found to have violated something that you want to mess around with. Also, AB 60 requires the California DMV to issue a driver's license to the undocumented person who can prove identity and California residency, and they can meet some other requirements as well, such as the written and behind the wheel exams. The card will bear a notation that the card is not acceptable for federal purposes, such as verifying eligibility for employment. This takes place January 1 of 2015, so next year. However, you need to train all involved with I-9 verifications that they are going to be seeing these cards. And even though it may look, I haven't seen one of these cards specifically, but you need to train your people that it may look like a driver's license, but they need to be aware that there's going to be a seal on there that says not eligible. not acceptable for verifying employment eligibility. Much like there are Social Security cards that bear the same kind of seal, so they just need to be trained a little. Whistleblower protections, Senate Bill 496 prohibits the employer or any person acting on behalf of the employer. So whether it be an attorney or any employee, a manager, anybody, this prohibits them from making, adopting, or enforcing any rule, regulation, or policy that prevents an employee from disclosing information to a government or law enforcement agency. And it also prevents any person, again, acting on behalf of the employer from retaliating against the employee. So be real. This next thing involves San Francisco workers only. So even if you are an employer that is not based in San Francisco, but you have someone working in San Francisco, there are a number of things that happen only in the city of San Francisco that you must be adhering to. So this deals with the family-friendly workplace ordinance. They must consider requests for flexible or predictable working arrangements to assist with caregiving responsibilities, and the employees are protected from adverse action. There also is an updated workplace posting, so you need to post that. And I think that is it. Yes. If you do have any questions, my name is Judy Ballard with HRnow Incorporated. You can reach us here at our HR hotline, 714-393-9270, or you can reach me by email by judy@hrnow.us. Thanks for watching.